Hey, Brian Douglas here. This week's blog is about escrow and the closing process in Georgia. So depending on if you're from Georgia and used to Georgia customs and real estate or not, in Georgia we call it a closing, but if you're from California, you don't call it a closing, you call it escrow. So the terminology can sometimes be confusing depending on where you came from. So in Georgia, when we're talking about escrow, we're generally talking about someone holding something in escrow, usually money. So when it comes to a real estate transaction, in Georgia, what we're really talking about is the money, and usually just the earnest money. So when an offer is written to buy a house, the buyer submits an offer, and in there they say they're going to pay X amount of dollars of earnest money. $5,000, $10,000, doesn't really matter, it's part of the contract. And the seller accepts. Well, then the buyer has to pay that money to the escrow agent within a certain period of time pursuant to the contract. So who is the escrow agent? Well, it's generally a number of different people or really entities. Oftentimes it's the closing attorney. So if I'm doing the closing, the parties may say, we want Brian to hold the money. So the $5,000 earnest money would come and sit in my trust account or escrow account. But sometimes it's the broker. And what I mean by the broker is, if the buyer has an agent and the seller has an agent, they each have a broker backing that agent or that they work under. So sometimes the buyer's agent will hold it, usually the buyer's agent or the attorney, could be the seller's agent as well. So why is this important? Well, if everything goes through with the closing and everything's good and fine, it's really not important, because at closing, what the contract says is that the escrow money is applied to it. So if you were paying $100,000 for the property and you put $5,000 down, you would have a $5,000 credit on there, and you'd have to bring $95,000 in some fashion or form. But what happens if the contract goes wrong? This is where it gets super important, right? If there's a dispute over the earnest money, if one of the parties doesn't perform, if something bad happens and then we never get to closing, now you have this third party holding the escrow money, and they have to basically make the decision on who gets the money. So we become, as much as we don't want to, we become stuck in the middle between a buyer and a seller, both potentially fighting over the money. And at the end of the day, whoever's holding the money, it's not their money, and they understand that, and they want to give it to somebody, but they don't know who to give it to. So for me, I think it's super important to know who's holding the earnest money, because I would either want a completely neutral third party, or at least somebody that's representing me on my side, like if I'm the buyer on the broker side. Now, if you're the seller, you may want your broker to hold the earnest money, and that's a point of negotiation. Again, 99.9% of the time, everything goes according to plan, and the money's applied to closing. But in the times that it doesn't, it is super important that you have the right person, because if the dispute gets too large, the only thing that the escrow company can do is basically go to court and give the money to the court and file a lawsuit against everybody and say, court, we don't want the money, it's not our money, someone else gets it, they're claiming it, you decide. And then you're forced into a lawsuit with each other, and you're gonna spend a lot of time and a lot of money in court. So if you have questions about escrow, certainly check out this week's blog. There's a lot more information in there. As always, we're here to help. Anything real estate, give us a call, reach out. We'd love to talk to you about it, help you in any way we can. That's all we've got for this week, and we'll see you next week.